Hello, I'm still Stephen Gold, the author of The Return of Breaking Law, and there's not much now I can do about it. Of course, you could read the book.
Get on with it, Gold.
Quite. Some welcome news for business tenants who fell into arrears because of the pandemic. A new act has come into force, which is aimed at helping out business tenants over money owed to their landlord for rent and service charges, which were clocked up because coronavirus laws forced them to close or restricted what they could do at any time during this period, generally the 21st of March 2020 to the 18th of July 2021 in England or the 7th of August 2021 in Wales. If an agreement cannot be reached on what should be done about the debt, either landlord or tenant can have the dispute arbitrated. This is in place of any court proceedings. The arbitrator is given a wide discretion in deciding how much of the arrears, if any, should be paid and how. Some of the arrears might be wiped out. The tenant might be given time to pay, up to 2 years. Interest on the arrears might be reduced. But to find in the tenant's favour, the arbitrator must be satisfied that the business is viable, or would be, if the tenant's obligations were eased. At the same time, the arbitrator will have an eye on preserving the landlord's solvency. We can't have the landlord going to the wall, can we? The time for asking for arbitration will end on the 24th of September 2022. If arbitration hasn't been asked for by then, the landlord can follow through their normal remedies for getting their money.
We're just a minute or so into this video and you haven't yet uttered a single word about the new divorce laws that came into force on the 6th of the month.
I have mercy on our viewers. My 20-minute video on the reforms is still up and running where this video can be found. Well, the laws duly came in and the website for bringing proceedings online hasn't crashed yet. Some 3,000 cases were submitted online in the first 4 days of the new law coming into force. Well, there's been one other development on the matrimonial front that I can report on. For a while, a special online scheme has been running in divorce cases only for getting a judge to make an agreed order dealing with financial matters. So much faster than sending in the paperwork to the court by post, which could take several months to be turned round. Well, that online scheme has now been extended beyond divorce cases, so that it now covers agreed orders in civil partnership, nullity, separation, and for variation of previous orders as well. Well, enough on falling out of love. Have you ever been in love with your bank?
Only when I badly wanted an overdraft.
I understand. Well, if you can bear it, here is news of a court ruling that has just gone against a bank, Barclays. A music teacher and her husband, a retired consultant physician, they were duped by fraudsters into agreeing to pay over some £700,000, that was the bulk of their life savings, from their Barclays account into what they believed was a safe account identified to them by the fraudsters. This they ironically thought would protect the £700,000 from fraud. Well, the music teacher went along to 2 separate branches of Barclays and gave instructions to each for tranches of the money to be transferred over. Barclays obliged, and the money was never to be seen again, at least not by the music teacher and her husband. Well, the music teacher, on behalf of herself and her husband, she sued Barclays. She claimed that the bank had been under a duty of care to the couple and that they had breached it in transferring that money. Now, it's established law that a bank is under an obligation to a customer to use reasonable care and skill in carrying out the customer's orders. A bank would have to compensate a defrauded customer where it took some action when it knew that somewhere dishonesty was involved, or where it shut its eyes to obvious dishonesty, or where it was reckless in failing to make the sort of inquiries that an honest and reasonable person would have made. But in the music teacher's case, the fraudster hadn't given the transfer instructions to the bank. No, they'd been given by the customer herself. Did that make any difference? Well, the Court of Appeal ruled that it didn't. The same principles applied, and that being so, the bank's attempt failed to get the claim slung out early. Now, a judge will hear full evidence and decide whether the bank should have smelt a rat and not automatically carried out the wishes of the music teacher.
But court proceedings against banks carry financial risks, don't they?
Well, the reality, my dear pessimist, is that all court proceedings carry some sort of risk, and proceedings against mighty banks are no exception. There's an alternative to actual court proceedings, though, where you're gunning for a bank or other financial institution, and that's a complaint to the Financial Services Ombudsman, who can direct the bank or whoever to pay you compensation. The complaint could be about anything from a bank loan, payday loan, mortgage or other credit, to a pension. And the Ombudsman has been upholding around 3/4 of complaints by victims who have authorised payments as a result of some scam.
That compensation a victim can obtain through the Ombudsman, is there any cap on it?
Well, yeah, there is, and the figures have just been increased for complaints made on or after the 1st of April. For anything you are complaining about that happened after March 2019, the limit has risen from £355,000 to £375,000. And for anything that happened before then, the limit will be £170,000. That's an extra £10,000. Now, compensation can reflect distress, inconvenience, pain and suffering, and damage to reputation over and above the actual financial loss you suffered. But failure to convince the Ombudsman doesn't preclude you from taking court proceedings against the financial institution after you've stabbed the Ombudsman rejection letter. And we stay with some other compensation limits which have been hiked. These are for compensation which can be awarded by employment tribunals, and they relate to employer misdeeds such as unfair dismissal on or after the 6th of April. The limits have gone up by a stonking retail price index increase of 4.9%. That means that the compensatory award for future loss in unfair dismissal cases could reach almost £94,000. On top of that, there's a basic award in unfair dismissal cases, and for calculating that, along with redundancy payments, reference is made to an artificial 1 week's pay. The limit for that 1 week's pay has increased from £544 to £571. Finally...
Didn't think we'd ever get there.
Oh, don't worry about him. It's another 5 minutes to his tea break. Finally, compensation for personal injury in an accident. If you've made a compensation claim, or are about to do so, you could be in for more than you had reckoned on the basis of what you've been advised. The amount of most compensation awards is based on guidelines issued every couple of years by the Judicial College. That's the outfit which attempts to train judges into how to conduct themselves in court and keep them up to date if they don't watch these videos. Each time the guidelines are updated, the recommended range of compensation for a plethora of injuries and conditions rises, principally because of inflation. Well, the fresh guidelines have been issued. My message is ensure that the compensation you receive is based on these latest guidelines and not those issued previously. It's the 16th edition of the guidelines and not the 15th on which your compensation should be based. The guidelines do not affect compensation for whiplash injuries, suffered in a traffic accident which occurred on or after the 31st of May 2021 and where symptoms have cleared up within 2 years. There's a special scale of compensation there, and it's mean. Compensation for a whiplash which clears up within 3 months, for example, could be as little as £240. Well, more of this in my blog and in my book.
Stop it.
Sorry. How you make a personal injury compensation claim has got a bit complicated. Whiplash claims which are not agreed will be decided as county court small claims. Other traffic accident cases worth no more than £5,000 for personal injury, which don't fall within the whiplash scheme and where the accident occurred on or after the 31st of May 2021, will also be dealt with as county court small claims. A personal injury case which has nothing to do with a traffic accident will only have to be dealt with as a small claim if the value of the injury is £1,500 or less. The limit was £1,000, but has just been raised for accidents occurring on or after the 6th of April. Well, that's it. Till the next time, happy litigating. Goodbye.